This is a lecture for professional responsibility, and we're going to be talking about ABA Model Rule 1.3 that addresses diligence, the diligence requirements for lawyers. Please be aware that in some states, we're going to express this in the negative when they describe their rule and call it neglect of a client matter. So if you're wondering what does diligence mean, it means not dropping the ball or neglecting a client's matter. It means that you work the case when you agree to take it. And I want to say something else before we proceed to the rule. The Texas bar, at least that's where I teach, says that there are two rules, the violations of which constitute most of the client complaints or grievances and most of the disciplinary actions that the bar has to take. And that's the failure to communicate and neglect of a client matter. And so now lots of other rules are going to be tested more heavily on the MPRE than this rule, but in your life, this is one of the two rules you are most likely to get in trouble for violating, and it's just straight up, you get overwhelmed, you take on too many cases, and you procrastinate on one of them or take too long, and that's neglect of a client matter or a lack of diligence. And so this is one of our areas most likely, our two areas or rules most likely to generate a grievance, like getting your license suspended. And here's the whole rule. A lawyer shall act with reasonable diligence and promptness in representing a client. That's Rule 1.3. Now, the comments have a bit more to say about this. And they're also going to say some things about what this doesn't mean. So, comment 1, a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, personal inconvenience to the lawyer, and take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. And a lawyer must act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. If you're in law school, you must have by now heard people throwing around the phrase zealous advocacy. Clients are entitled to zealous advocacy. You as a lawyer are supposed to provide zealous advocacy. And that means that you go ahead and pursue every case and give it your full, right? That every client deserves to have you try your best, essentially, at their case. You are not bound, notice this caveat of what it doesn't mean, to press for every advantage that might be realized for a client. And they give an example. A lawyer may have authority to exercise professional discretion in determining the means by which a matter should be pursued. And so if you have a client who's been wronged by another party, you don't have to file pleadings and pursue litigation immediately. A lot of times just sending a demand letter and negotiating with them will resolve the matter. Or talking about opportunities to resolve it without litigation and so forth. So zealous advocacy does not mean you have to file a lawsuit every time. Zealous advocacy does not mean that you have to put every provision you could possibly think of in the contract, right? Some people want a contract that's straightforward and not 2,000 pages long. And so you don't have to put everything that anyone has ever put in a contract into your contract every time. I'm going to give one more example. Let's say you have a client who is the victim of medical malpractice, right? Well, the client wants to be made whole. They want some compensation for their bills, their pain and suffering, or lost wages, and so forth. It doesn't mean that you have to go and try to ruin the doctor's life, right? It could have been just an innocent mistake. Doctors are human too. And it may have been negligent to the point that they or their insurer should have to pay compensation, but not necessarily that you should have to file a grievance with the medical licensing board and try to get their medical license revoked and so forth. Some of that's kind of could be taking it to an unnecessary extreme. A lawyer's duty to act with reasonable diligence also does not require the use of offensive tactics or preclude the treating of all persons involved in the legal process with courtesy and respect. And I want to pause right here for a moment and say something. When people talk about legal ethics, not non-lawyers, non-lawyers assume that legal ethics should mean you can't lie and you can't steal money and you can't destroy evidence and all of the stuff they've gotten from TV shows and movies. If you talk to lawyers about how we need to do a better job of teaching legal ethics, they're often talking about simple civility between lawyers, lawyers being respectful and polite and not rude and so forth. And in here in Texas, we have a division of the bar that's basically advocates for more professionalism. We have a lawyer's creed. Um, that's about that a lot of it is about being respectful and civil and professional and so forth. And so zealous advocacy does not mean you get to be a jerk. It definitely doesn't mean you have to be a jerk. And I want to go back to this comment for a moment and have you take another look at it. When you are in law practice, I want to tell you there are going to be lawyers who are mean to everyone, unnecessarily rude. They scream and swear and pound the table all the time. And if you're one of those people, the rest of us talk about you behind your back. I just want you to know. And when I was in practice, if we knew a lawyer who would scream and swear and pound the table, we all assumed that they were compensating either for a lack of intellect on their own, a lack of skill, or that they had a really weak case. And so now the lawyers who are rude and unnecessarily combative and offensive and things like that, when you confront them, you know what, they will always justify it saying, I'm just providing zealous advocacy for my client. Always, always, always. That's what and you know what, the ABA has now said, has put it right here. Zealous advocacy does not mean being offensive or treating people disrespectfully. Comment 2, and this, by the way, make sure you pay attention to this one. This does show up as test questions on the MPRE. A lawyer's workload must be controlled so that each matter can be handled competently. And this is the point where 1.3 and 1.1 have a kind of a complex interdependence. And so lawyers can take on too many cases and to the point where they get overwhelmed and get in over their head and start kind of shortchanging either all of them or some of them, right? They get engrossed in some cases and neglect others. And you have an ethical duty to control your own caseload, which means turning away clients or withdrawing from cases when you're some cases when you're overwhelmed with others and so forth. And it's not going to be an excuse for your mistakes if there's a disciplinary action that you just had too many cases and it was too hard. And I want to talk about this for just a moment and give you 3 scenarios where this works. And part of this is for your for life advice. And one of the scenarios turns up on the MPRE a lot. And I'm going to start with that one. And this is about public defenders, people doing public defense work. And so it turns out that there's more people who need a free lawyer, criminal defense attorney, than we have funding to provide at the public defender's office. And so sometimes the public defender's office will get overwhelmed and they have to kind of offload clients that tell the court, we can't take any more, we can't represent anyone else. Call the lawyers on the court-appointed counsel list and farm some cases out to private practice lawyers. But I can tell you, having been a legal aid lawyer, that a lot of times you have somebody who is directing a public defender's office or a legal aid clinic who's a real believer, like they're a real idealist, and it just kills them to turn people away who need their help and they know aren't going to get as good a help elsewhere. And public defenders tend to be pretty good, right? There's a lot of people that want to do it. They can hire the best, and you get a lot of practice. And so it's not a high-paying job, but they're competent. But the problem is that, let's say you're a new lawyer at the public defender's office. You go to your supervisor and say, I have too many cases, don't give me any new cases. And some of them will say something like, look, isn't it better for this person to have an hour of your time than nothing at all? I would rather have they have a little bit of help from you, even if you can't work their case fully. And plus, you're probably going to settle before trial. They're going to take a plea bargain 95% of the time, and so you don't put up a fight and you take the next case, and then it's another, and then it's another, and the answer is always, I'd rather give them a little bit of help than none at all. And that is not the legal standard, and you can find yourself subject to discipline. Here's our two other scenarios. Number one, you get one of those big firm, high paying dream jobs after graduation. So you're at Big Law, and at first it's all well and good. And then they start giving you more and more cases, right? And more assignments, and you get overwhelmed. And you're billing lots of hours, you're working on the weekends, you're staying late at night, and so forth. You don't have a life outside of work. And some partner stops you in the hall or says, hey, come to my office. I have a case I'd like some help with. And if you haven't made partner yet, if you're a new associate at a big firm, it's pretty daunting to say, I have too many cases and I can't take any more work on from you. And you risk that partner having a grudge against you or feeling snubbed, and then either being out to get you, or telling themselves, I'm never going to ask that guy for help again. I'm never going to offer to give that guy work again. And I have known former students who went to work for big firm jobs. A number of people have had this happen to them, where the year that they're supposed to come up for partner, no one's giving them any cases anymore, and because they've had to say no, or for whatever reason, and now, because nobody's giving them work, they can't meet their billable hour requirements. And it can be I'm just telling you, as law students, it can be hard to imagine how hard it is when you're in practice to say no to a partner at a big firm. And then here's our last scenario, other extreme. You hang out a shingle after graduation and decide to be a solo practitioner, and that's awesome because you're your own boss and you don't have to worry about partners dumping work on you, or how to muster up the courage to say no to people and things like that. And here's the problem for solo practitioners, especially when for the first several years that they're launching their firm, it tends to come in, the clients tend to come in waves, and it's months of feast and months of famine. And a lot of the people, when they're starting their own firm, again, it's a few years of this, very commonly, that you could all of a sudden, it's been 3 months or 6 months since the last time you had a new client sign you up and agree to have your representation. And at first you don't notice because you're busy with other clients, and then you're like, gosh, I don't have anything to do, and I don't have any new clients. And so then all of a sudden you get some clients, and one day you walk into your office and your waiting room is full. And I don't know if you ran a new ad, or it's just actually life just tends to go in cycles like that. So all of a sudden you have a whole bunch of new clients, and you take all of them and you're excited, and now you're in the big time, you think, and you've got it made, and you're thinking, maybe I should hire an associate and so forth. You're super busy, and then all of a sudden it stops again. And you go through these cycles, and a few months of lots of clients and a few months of no new clients. Sometimes it's a long time, 6 months, 9 months of no new clients, and you start to get scared. You're worrying, you're having to take out of your savings to make rent and so forth. And let me tell you, that next client that comes in, the next time you walk in and your waiting room is full, it's really hard to turn people away, because even though you're now taking on more people than you could handle competently, you're worried that after this wave of clients comes in, how long will it be before I have another one? And so this can also be a temptation for the solo practitioner. Once you get used to the fact that the business comes in waves, or the feast and famine cycles, you get nervous about turning people away, because you're not sure what if this is the end of the boom time, and we're going to have to live off of these cases for a long time. Okay, procrastination. This is comment 3. And it says almost probably nothing is resented as much as this. People really hate this. When they hire you to do a case, it doesn't seem very important to you. A client's interests often can be adversely affected by the passage of time or changing conditions. And in extreme instances, when a lawyer overlooks a statute of limitations, their legal position could be destroyed. But as a law student, lots of students are aware of the statute of limitations, but there's also filing deadlines for replying to things. When someone has an issue receives an adverse decision from a licensing board, there's a set number of days to request a hearing to challenge it. Otherwise, you're stuck with it, and then you don't get to challenge it in court because you didn't exhaust your administrative remedies. All sorts of things can go wrong, and also just putting off a case too long can mean that evidence goes away. Evidence is lost, witnesses' memories fade, and so forth. And so just the delay can be hard for your client. Even when a client's interests are not affected in substance, however, unreasonable delay can cause a client needless anxiety and undermine confidence in the lawyer's trustworthiness. It really bothers other people more than it bothers you, that you take so long to do things as a lawyer. A lawyer's duty to act with reasonable promptness does not preclude the lawyer from agreeing to a reasonable request for a postponement that will not prejudice the lawyer's client. So when the other lawyer, but we're cautioning you about this. This doesn't mean that your need to not procrastinate. It means you can never agree to another side's request to postpone things or continue things because they need a little more time. It's a professional courtesy, and you should usually say yes, because next week it's going to be you. Next week you're going to be the one who's in the middle of a 2-week trial, and you have a 2-week deadline on responding to someone's motion in another matter, and you would like the courtesy of having a little extra time to file a reply brief. Comment 4. Unless the relationship is terminated as provided in 1.16, that's our termination rule, like the things that you have to watch out for when you end the representation. A lawyer should carry through to conclusion all matters undertaken for a client, and if a lawyer's employment is limited to a specific matter, the relationship presumptively terminates when the matter has been resolved. Now, I'm going to tell you in practice, you should still send a letter to the client saying, this ends my representation of you. If they're not a lawyer, there's a lot of unsophisticated people out there who they hired a lawyer once 10 years ago, and still every time they get in an argument, they talk to people like, oh, I'm going to have my lawyer talk to you like they have you on retainer, and you haven't thought about them in years, right? But once you do legal work for some people, you're their lawyer for life in their mind, and you're still working for them in their mind. So it's really good to avoid misunderstandings and notify your client, I'm not representing you anymore because this concludes the matter. I'd be happy to represent you again in the future. If you've served a client over a substantial period in a variety of matters, the client may sometimes assume that the lawyer will continue to serve on an ongoing basis until the lawyer gives notice of withdrawal. Now, I know what I just said, that if you do something, a one-off for somebody, a lot of them are going to think that you're their lawyer for life and that you're officially their lawyer now. But it's particularly acute when you've done legal work for someone like a small business owner for 3 or 4 or 5 years, and they'll just assume that that's going to continue. And sometimes you've moved on, you want to change firms or go into a new area of law, and communication is everything here. So doubt about whether a client-lawyer relationship still exists should be clarified by the lawyer, preferably in writing, so that the client will not mistakenly suppose the lawyer is looking after the client's affairs when the lawyer has ceased to do so. For example, if a lawyer has handled a judicial or administrative proceeding that produced a result adverse to the client, and the lawyer and the client have not agreed that the lawyer will handle the matter on appeal, you must, this is a have to, and this is a testable either or question for the MPRE, you must consult with the client about the possibility of appeal before relinquishing responsibility for the matter. And so please keep this in mind. A very common source of grievances and misunderstandings between the lawyer and the client. You do someone's trial, and it would never occur to you that you're going to do the appeal, and it would never occur to your client that you wouldn't do file obediently for appeal. It might be clear to you there's no appealable issues. We gave it our best shot. You've got to explain that to the client. You've got to explain it to the client. And then this is also very true with administrative proceedings. there are certain lawyers, and you have an area of practice, it could be immigration, Veterans Administration, Social Security, something like that, where you're at the front end, like when people are applying for things. And so you're used to filling out forms for people, and getting the information that they need and stuff like that. And you don't do the hearings. Well, if you're not going to do their hearing when they get denied, you've got to tell them that. Um, okay, this is almost a specific rule that I wish they had done as a standalone rule instead of burying it in comment 5 to rule 1.3. Sole practitioners, if you are practicing alone as a sole practitioner with your own law office, you must have a contingency plan in conformity with applicable rules that designates another competent lawyer to review client files, notify each client of your death or disability, and determine whether there's a need for immediate protective action. And I talked about this a little bit under Rule 1.16 in that video lecture. This is an ethical duty, and if you don't have this plan, you are in violation and could be subject to discipline. And listen, I hope this nothing happens to you, but a lot of people die, right? And people get into accidents, people get sick, and then a whole bunch of people at some point get in an accident or go through about where they're in the hospital with an illness or something like that. And when that happens, when you are very suddenly taken out of commission, there has to be somebody that has agreed in advance that they're going to go to your office, and hopefully your support staff knows who this is so they can contact them. They're going to go to the office, sort through the files, triage. They're going to, by triage, I mean they're going to be looking for who has an upcoming deadline. It's going to be a nightmare if we miss this, and they're going to address that, prioritize those, call anybody where there's an open matter before an agency or a court, and notify them that something has happened to you, that you're either incapacitated or incarcerated or dead, and that they need to be substituted as the attorney of counsel for the time being. And then every client gets a letter saying something happened to your lawyer. This is what happened to your lawyer, and he's either temporarily or permanently out of commission, and he has asked me to take over the matter. And you will explain to them that they have a choice about whether they want to take this opportunity to look for another firm, or if they're willing to just go along with you. And it goes both ways. There's some clients who are like, you know what, if I'm going to start over anyways, I'd rather shop around a little bit and find a lawyer with a better price or who's closer to where I live or something like that. And other people are going to trust you because their lawyer trusted you. So that's the sole practitioner rule, or that you have to have a plan for your worst case scenario, and what to do. And that concludes our lecture about Model Rule 1.3.